My name is Yogya Bhatia and I'm a legal intern at LEXIS and Company. Today I'll be talking about kidnapping and abduction. Though Indian laws prohibit abduction and kidnapping since 2005, more than 100,000 kidnapping and abduction cases have come up in India. People have continued to take advantage of the tender age of minors to kidnap them and exploit and force them to perform horrendous acts. Such offences are an attack on the liberty and freedom of citizens and must be prevented. Section 359 to 374 of the Indian Penal Code 1860 provides for punishment for these offences. In this article, we will discuss these provisions in detail, understand the essential of kidnapping and abduction, discuss the difference between kidnapping and abduction, also discuss the provisions regarding forced slavery, labor, and sale and purchase of minors for illegal purposes. Kidnapping. Kidnapping means taking away a person against his or her will by force, threat, or deceit. Usually, the purpose of kidnapping is to get a ransom or for some political or other purpose, etc. Kidnapping is classified into two categories in Section 359 of the Indian Penal Code and defined in Section 360 and 361 of the Indian Penal Code. As per Section 359 of the Indian Penal Code, kidnapping is of two types: kidnapping from India, kidnapping from lawful guardianship. Kidnapping from India. Section 360 explains kidnapping from India. According to Section 360, if any person takes a person beyond the limits of India against the consent of that person or against the consent of someone who is legally entitled to give consent on the person's behalf, then the offence of kidnapping from India is committed. For example, A is a woman living in Delhi. B takes A to Bangladesh without her consent. B committed the offence of kidnapping A from India. Keeping of lawful guardian. Section 361 explains kidnapping from lawful guardianship. According to this section, if a person takes away or entices a minor, that is a boy under the age of 16 years and a girl under the age of 18 years, or a person of unsound mind away from his or her lawful guardian without the guardian's consent, then that person commits the offence of kidnapping from lawful guardianship. Thus, the essentials of kidnapping from lawful guardianships are that for example, A is a boy of 13 years of age, living under the lawful guardianship of his mother. Z and B convinces him to accompany him to his house against the consent of his mother. According to Section 361, B has committed the offence of kidnapping from lawful guardianship. Here, the minor A is the lawful guardian, his mother Z, and the person who has committed the offence is B and is taking A from Z against Z's consent. This section also mentions an exception. It says that it does not result in the crime of kidnapping from lawful guardianship if the person in good faith, that is honestly, with the reason believes that he is entitled to the lawful custody of the child or he is the father of an illegitimate child. Hence, if in the above illustration B believes that A is his illegitimate son, then his act of convincing him to come to his house without his mother's consent would not result in kidnapping from lawful guardianship. State of Haryana versus Rajaram. To understand this better, let's look at the case of State of Haryana versus Rajaram. J had tried to seduce the prospect girl of 14 years to come and live with him. The girl's father forbade J from coming to the house, and in response, J started sending her messages through the respondent. One day, the respondent went to the girl and asked him to come to his house and later sent his daughter to bring her. At his house, the respondent told her to come to his house at midnight so that she can be taken to J. Judgment. The trial court held him guilty, but the High Court acquitted him. One appeal to the Supreme Court, it was held that Section 361 is to protect minor children from being seduced for improper purposes and to protect the rights and privileges of guardians having their custody. The consent of a child is completely immaterial and only the guardian's consent is relevant to decide whether the offence was committed or not. Taking, as mentioned in the section, is not through fraud or force and also through persuasion by the accused, which creates willingness on the part of the minor to be taken away from his or her legal guardian. Age of the minor. Section 361 of the Indian Penal Code clearly states that the minor, a male under the age of 16 years, a female under the age of 18 years. However, it must be highlighted that in Manipur, the age of 18 years of female in Section 361 is replaced with 15 years. Hence, if a female of 16 years is taken from a lawful guardian in Manipur, it would not result in kidnapping from lawful guardianship. Moreover, the Allahabad High Court in Srimati Suman and another was a state of Uttar Pradesh gave a peculiar judgment. It was held that if a minor girl who is 17 years old and is mature enough to understand the consequences and rationale behind her action, leaves the guardianship of her parents to live with a boy who is in no way subjected her to any kind of pressure, inducement, etc., cannot result in an offence under Section 361 of IPC and is not punishable. Thank you.